Welcome to Legal Lines. My name is Tom O'Shea. I'm the host of the show. And today my guest is attorney Craig Milsten. Our topic is auto accident law. Craig is an attorney with the law firm of Catherman, Briggs & Greenberg. Welcome, Craig.
Thanks, Tom.
And like I said, we're going to be talking about auto accident law. I know you handle a lot of those types of cases. And in Pennsylvania, there is something known as no-fault auto insurance. And the first question I have for you is, what is no-fault auto insurance?
I think that is a term that can be confusing to people because it seems so all-encompassing about auto accidents. But the term no fault itself only applies to the application of insurance to your medical benefits, essentially how your medical bills are going to get paid. So when we say no fault, all that means is it doesn't matter who caused the accident. It doesn't matter whose fault the accident was, only with respect to who's going to pay your medical bills. In Pennsylvania, your medical bills are first paid by your auto insurance. So when you contract for your insurance and you're deciding what your different levels of coverage are going to be, one of the decisions you're going to make is what's called your first party benefits, which includes your medical benefit. And that level starts at $5,000 and it goes up. You could have $10,000 or $25,000 or more, but it starts at $5,000. And what that means is if you get into an accident, even if the accident was the other driver's fault, it is going to be your insurance that pays your medical bills first until that level of insurance is exhausted. Now, it gets a little more complicated after that happens.
Well, the first thing that I know in Pennsylvania, if you want to drive, if you have a car and you want to drive it, you have got to have auto insurance. It's required.
That's right.
But does the law require how much auto insurance you need?
There are certain aspects of your insurance that the law does stipulate a minimum level. And you're, of course, right, that every driver on the road is required by law to have insurance. Now, we both know that doesn't mean that every driver does have insurance, but yes, you are legally required to have it. The minimum amount of liability coverage that you can have on your insurance is $15,000. And by liability coverage, I mean the amount of money that you have available to you to help compensate another driver if you are at fault for an accident.
All right, so here fault will play into the issue of liability because the no-fault law, all that is referring to, as I understand it, is your medical bills.
That's right.
Other losses could include, like if you can't work, you lose your income, you might have some pain and suffering, you might have other damages resulting from the accident that are not covered by your medical bills. But the no-fault only applies to medical coverage.
Right. No fault only applies to the application of insurance to medical bills and how they get paid. For virtually everything else that has to do with an auto accident claim, fault is very much
So when you use the word liability, somebody is liable for the damage that they caused if they caused the accident.
That's right.
That's basically what we're talking about here. And so there are liability limits. You'll hear somebody going to buy an auto insurance policy and they talk about the liability limits. Is that how much coverage they would have if they injure somebody else as a result of an accident that they are at fault?
Exactly. Again, when you acquire your insurance, you make a decision about what levels of coverage you want to purchase. Now, naturally, the more coverage you purchase, the more it costs. But the first level to be determined is your liability coverage. And again, that's the amount of money that your insurance will provide for you to pay to another driver that you injure if you're at fault for the accident.
Now, does the requirement that everyone have auto insurance have a requirement as to how much, at a minimum, they have to have in liability coverage?
Yes. And again, that limit is $15,000. So if you have auto insurance in Pennsylvania, then you have at least $15,000 in liability insurance coverage. In fact, I'm sure you've seen the commercials now that focus on minimum coverage and minimum requirements. That's what they're talking about. They're talking about providing you with $15,000 in liability coverage. Now, that would be your least expensive policy, but of course, if you injure another driver and that driver's losses are greater than $15,000 and you've only got $15,000 in coverage, your insurance may pay that $15,000, but you may be then responsible for anything above that.
So it would not be wise for someone to get a limited amount of liability insurance if they had assets that they could lose if a judgment was entered against them for causing an accident where the damages were far in excess of $15,000.
That's correct.
So someone looking to purchase insurance should certainly take that into account. I would assume that would be the wise advice to give.
Well, and that's, of course, the goal of insurance in the first place, is to provide protection for us and to protect the assets that you have. And so, again, if you have the means to have more in liability insurance there, then you're essentially just ensuring the safety of your other assets.
Now, for the liability, what types of things does the liability insurance cover if it doesn't cover the medical expenses?
Okay. Medical expenses really are an entirely separate aspect of a claim in the way that they get paid. And I think the reason why it is that way, to give you some insight to that, is our legislature has decided that first and foremost, we want people to be able to get the medical treatment that they need after an accident. And so that's why your own insurance company pays that. And this is an agreement that all of the insurance companies have made and our legislature has dictated, is that we want people to be able to get the treatment. If you had to rely on the other driver's insurance company to pay your medical bills, that can be an adversarial proceeding. Are they really necessary? How much is necessary? And they don't want people to not be able to get the treatment they need while that disagreement plays out. With respect to every other aspect of a claim, and perhaps I should start this way, if you are the one that's injured in an accident, and the accident's not your fault, that's important, then you are entitled to essentially two broad categories of damages. One's called economic losses, and one's called non-economic losses. Dealing with the first one, the economic losses, that means actual money that you've lost as a result of being in this accident. For most people, the primary examples of that are lost wages if you're unable to work, and then out-of-pocket medical expenses. Assuming that your medical expenses are greater than the amount of medical benefits you have under your auto policy, you may then start to incur some out-of-pocket. You may have to either pay for it yourself, or if you have health insurance, that will actually kick in at that point. But, of course, you'll have some out-of-pocket expenses with that as well, deductibles and copays and the way most people's health insurance works. So those are your economic losses for the most part. That other broad category that you're entitled to is called non-economic losses, and that essentially is pain and suffering, loss of life's enjoyment, inconvenience. It's all of those aspects of getting injured in an accident that basically encompass how unpleasant it is for you. So when another driver has liability coverage, again, at least $15,000, it can be more than that, that is coverage for that driver to compensate you for whatever economic or non-economic losses it's determined that you're entitled to.
Well, the economic losses seem much easier to be able to define. I assume
in most cases they are, yeah. That can be an objective thing. If you earn $100 a week and you miss 4 weeks of work, there's $400 in losses.
But the pain and suffering
Yes.
is much more difficult.
That indeed is the trick, Tom. How do we take what somebody, what you go through? How do we take pain and suffering and inconvenience and somebody's injury and put a dollar amount on it? And it's kind of a very long discussion in and of itself, but in a nutshell, you can look at it this way. Every claim is going to resolve in one of two ways. Either it's going to settle, in other words, both sides are going to reach an agreement on a certain amount of money. This is what's going to get paid, and that's going to be the end of the claim. Or if it doesn't settle, the only other avenue that claim can travel is in litigation. In other words, a lawsuit gets filed, and then that claim, again, as long as it doesn't settle, continues through the litigation process until it winds up at trial someday, and then a jury decides what the outcome should be. And so to say how much is a given claim worth in pain and suffering damages is essentially to say, if that claim had to go to trial someday, what would a jury award you? And like I said, that's a That's an enormous topic of conversation
So it's
in and
sort
of
of
itself.
a guess, but you look at prior cases to give educated guesses as to what would be a fair amount.
It's a guess in the sense that anything can and does happen at trial. Juries are very unpredictable. And that's one of the reasons why most cases don't go down that road. Most cases do settle. And even of the cases that go into litigation, most of those do not actually go to trial at the end of the day. And one of the reasons why that happens is because of the unpredictability of what can happen there. There's a lot of risk on all sides. When we're trying to determine, in my line of work, handling accident cases for plaintiffs, how much a given claim is worth in terms of pain and suffering damages, what's the right amount to settle the case for, we rely on a number of things. First and foremost, you have to rely on your own experience trying cases. When you do this work like I do, which is to say to do it exclusively, when this is what you focus on, you tend to get to trial a fair amount, and you tend to get an understanding of how juries view cases. Now, every case is unique. There's 100 different variables that go into the outcome of a trial. But you do start to see certain recurring themes. And you start to see the way that juries will react to certain aspects of cases. And so we can rely on that and apply it to any given case and come up with an idea about how a jury is going to react to that. Now, beyond that, there are some database reporters that will tell you what juries do across the state and across the country in given cases. That can be illustrative. It can give you an idea about what happens out there. The problem with those is, like I said, there's 100 different variables that go into the outcome. When you look at a database reporter that just gives you a number that says, you know, in a neck surgery case, the average verdict is X, you know, all you know is it was a neck surgery case. You don't know all the other factors that went into that one. So that helps a little bit, but for the most part, you have to be familiar with the jurisdiction you're in and the juries that you're dealing with.
Okay, so basically what you're talking about here is if somebody's in an accident, the first thing they have to, if they're filing a claim for pain and suffering, the first thing they have to do is prove that the other side is at fault.
Right.
I mean, that would be the first element of the case.
Right. And let me touch on something you said there too, because I find there's some confusion about this. If you are injured in an auto accident, there is a difference between bringing a claim and filing a lawsuit. Sometimes I think there's a misperception that people think that by bringing a claim for damages that they are necessarily suing somebody, and you're not. Pennsylvania provides a 2-year statute of limitations for negligence cases, which essentially means, in this case, auto accident cases. Negligence means that somebody made a mistake, somebody did something they shouldn't have done.
Craig, I don't want to cut you off here, but before you go any further, we're going to need to break for a few moments, and we'll be back. My name's Tom O'Shea. This is Legal Lines. My guest is Craig Milsten. Thank you. Welcome back to Legal Lines. My name is Tom O'Shea, the host of the program. My guest today is Craig Milsten, an attorney with Catherine Briggs in Greenberg, and the topic is auto accident law. Welcome back, Craig. And we were talking right before the break about the difference between a claim and a lawsuit, and you want to make that distinction clear.
I think there can be a misperception that if you're injured in an auto accident and you bring a claim for your damages, I think some people perceive that as suing the other driver. And that's not suing the other driver. In Pennsylvania, the statute of limitations for an auto accident is 2 years. And what that means is you don't have to file a claim in court. In other words, sue the other driver for at least 2 years. Now, if 2 years comes up and you haven't filed something in court, then you could lose your claim, so you do have to do it within 2 years. But the net effect of that is it gives you a 2-year window to be able to evaluate your claim and discuss trying to resolve that claim with the other driver, or in reality with the other driver's insurance company. And so you're bringing a claim and you attempt to resolve it, you attempt to settle it. It's in everybody's best interest to settle the claim. Litigation or filing something in court takes a lot of time, it costs money, there's risk. Essentially, a claim would only get filed in court, you only would be suing the other driver if all of your attempts to try to resolve it first failed.
Okay, so because the statute of limitations is 2 years, many times people try to work out a claim to get a settlement prior to ever filing the lawsuit.
Right.
And then, but the thing they need to worry about is if the 2-year statute of limitations expires and they did not file the lawsuit, they may lose any right to pursue their claim.
That's absolutely true, and then that's not something to fool around with, and it's not something to go right up to the last minute on either. I'd, of course, advise everybody to contact an attorney immediately if you've been injured in an accident. It's good to have somebody on your side to help level the playing field, somebody whose interests are your interests, who can guide you through that minefield the entire way, and it's good to get that attorney on your side from the very beginning. If you let your case go until you're a week away from the statute of limitations and you start trying to call an attorney, that attorney's not going to be able to help you at that point. It's going to be much too close to the deadline.
Okay. One of the things I wanted to touch on, because we hear these terms, is full tort coverage or limited tort coverage. When people go out to buy a auto insurance policy, they'll hear these options, and most people don't really understand the difference between the two. So I'd like you to explain the difference.
Yeah, it's interesting. Nobody seems to know what any of their auto insurance means until they get into an accident, which is, of course, not the best time to learn what type of coverage you have. Full tort and limited tort can be confusing terms, but they're actually very important. And I would advise people to go check their policies and see exactly what they have and make sure they're making an informed decision. It has to do with the type of damages that you would be entitled to if you are injured in an accident that was another driver's fault. As I had explained before, there are those two types of damages. The economic losses, such as lost wages or out-of-pocket medical expenses, and then the non-economic losses, the pain and suffering and those other type of damages. If you elect limited tort, you're making a deal with your insurance company, and the deal is your premiums will cost a little bit less, but you are giving up your right to one of those types of damages, and the one that you're giving up are those non-economic losses, that pain and suffering losses. If you elect full tort, then again, you're paying a little bit more for your insurance, but you are entitled to both of those types of damages. So if you have limited tort and you are injured by another driver, then no matter how much pain and suffering you have, you will never be able to collect money for that, except unless you meet certain exceptions. There's a list of exceptions, but more or less if your injury isn't catastrophic in nature or permanent in nature, then you're not going to be able to get those pain and suffering damages. And again, there's other exceptions. I don't mean to make it sound so definitive, but without going into them.
Okay. The other terms that I hear is uninsured motorist coverage, underinsured motorist coverage. Now, what are they?
Another crucial element of your auto insurance. As we talked about before, the law requires that every driver on the road have auto insurance. The fact is that every driver on the road does not have auto insurance. There are people that drive that don't have it. There also are a lot of people that are driving that have, as we talked about before, that state minimum requirement of liability limits. That's where your uninsured and underinsured motorist coverage come into play. This is an optional coverage that your insurance offers you. It's exceedingly important. If you are hit by another driver and that driver doesn't have any insurance and you don't have uninsured motorist coverage, then there is literally you're not going to get anything from anybody. There's no insurance there to cover you for this accident, to pay for your pain and suffering or your lost wages or any of that sort of damage.
So basically the mandatory no-fault insurance that you would have will only cover your medical bills.
Right.
And because you didn't get
up to the limits of
up to the limits of the policy that you purchased, but you would not receive any type of lost wages or anything else because the other driver did not have insurance and you did not buy uninsured motorist coverage.
Right. There literally would be no avenue of recovery for you there. Now, the other example is, again, if you're hit by another driver, it's the other driver's fault, and that driver, for instance, has a minimum liability policy, a $15,000 policy. But let's say your losses are more than that. Let's say your losses are $100,000. Again, that other driver's insurance company may pay you the $15,000 in liability limits, but that's all you're going to get from them. Now, if you purchased underinsured motorist coverage on your policy, you can then turn back to your own insurance company, and then whatever coverage you had there will stack on top of the $15,000 that you got from the other driver up to the full value of your claim or the limits of the underinsured coverage that you bought.
So basically your own insurance is picking up because someone else didn't get sufficient insurance to cover the damages you sustained as a result of the other driver's fault.
Right.
Okay.
And again, I can't stress enough how important that coverage is when you're making decisions. For all the drivers that are out there that have little or no insurance out there, you can only imagine for most people if you get injured in an accident and you're unable to work for some extended length of time, you can either rely on that other driver to have enough insurance to compensate you, or you can make sure that there's going to be enough there to cover you.
So in the first instance with the uninsured motorist, technically that person's breaking the law. They don't have driver's insurance, motor vehicle insurance, and they're supposed to in order to have a valid, in order to be driving legally in Pennsylvania.
That's correct.
Okay, but the underinsured, they are fully within the law. They are providing the minimum amount of coverage that the law requires that they provide. It just might not be enough to cover most of the accidents that might happen, or many of the accidents that might happen.
That's right.
So what you're really doing then is picking up insurance for two extra reasons. One reason is there might be people literally breaking the law that you're covering yourself just in case they don't have any insurance, which is the uninsured motorist coverage.
Correct.
And you're also protecting yourself from the fact that many people, for whatever reason, just choose to get the minimum that the law requires, even though the damages might be well above that minimum.
Right. And again, if the other driver only has a minimum policy, oftentimes, and I don't want to generalize too much here, why people make these decisions, but oftentimes it's because they lack the resources to purchase more insurance.
That's basically the best they can afford.
They're choosing the least expensive option. Now, under those circumstances, you can usually infer that there aren't going to be any other assets there. It's not as though this person is going to have individual assets to help compensate you above their insurance. So whatever insurance is available there is all that there's going to be. And if you don't protect yourself with underinsured motorist coverage on your own policy, then no matter how badly you're injured, no matter how devastating the consequences are on your life, there simply will not be any resources there to compensate you.
But one of the interesting things then is that you're actually going to make the claim not only against the driver at fault who has underinsurance, you're also then making a claim against your own insurance company to cover the balance.
Well, that's true, and that's exactly what your insurance company contracted with you to do.
Okay.
It is an interesting point that you
sometimes
raised,
you have
because
disputes with your own insurance company.
You do.
Especially
I have clients that feel bad about doing that or don't want to make a claim on it. And that's, frankly, that's just silly. If you buy that coverage, you're paying the premiums on that policy. That's the deal that you made with your insurance company. That coverage is there for you. You've been paying for it for however long before the accident happens. You should use it.
Well, I can see with the actual damages, the ones that are easily proven, lost wages, how that's an easy claim. But the pain and suffering, which you explained earlier, you really can't define the exact dollar value. Do sometimes people get in disputes with their own insurance company as to how to cover them for their own pain and suffering?
They do. They do. There can be differences of opinion about what the right value is for that. And, you know, insurance companies don't want to pay any more than they think that
And
they have to. And so, yes, that does happen. And as a matter of fact, you know, without getting into it too deeply, because it's an extremely complex area of the law that's been evolving quite a bit lately, but in Pennsylvania, there's been some major changes on that. Not too long ago, all insurance policies in Pennsylvania provided that if you had that type of dispute with your insurance company, the matter would be decided in arbitration, which is a panel usually of attorneys that would hear the case and make a decision. It was a slightly more streamlined procedure to get things accomplished. Just in the last few years, there have been some seminal court decisions which have changed that and allow the insurance companies, if they choose, to require their own insureds to have to bring that claim in court, just like they would against the other driver, and proceed to a jury trial. And that's,
so
of
you're
course, a
actually
much
suing your own
lengthier.
insurance company.
You could wind up in a courtroom across the courtroom from your own insurance company, asking to be paid the benefits that you contracted for under your policy.
We only have a minute left, but one of the other things that I think is interesting is if you talk about a case going the whole way through the jury trial, does the jury ever learn how much insurance someone has?
No. In the most general sense, insurance is a forbidden word in this type of
They're not
trial.
even told whether someone is insured, let alone underinsured.
Technically, it should be irrelevant to the outcome of the case. The jury's supposed to decide what the case is worth, irrespective of that. And so, therefore, no, neither side is allowed to say that there is insurance there or how much it is.
So in the courtroom, it's the plaintiff, the injured party, suing the party who he alleges caused the accident. But no mention of the insurance company is there, even though the insurance company may pay. And before you answer, we're out of time. My guest was Craig Milsten. Our topic was auto accident law. This is Legal Lines. Thank you.